He walked into court facing a serious felony charge, possible prison time, and a complicated family situation. But what happens next is completely unexpected. Instead of sending him away, the judge gives him one more chance, but with strict conditions, mental health support, and a powerful warning about his family. And the judge's final words may be the most important part of this entire hearing. Stay with us to see how this case unfolds.
Hello, Judge. Hey. Hey, did I miss Daryl Lewis?
I just need some time. I forgot to write it.
Yesterday. I couldn't find that on the docket. Kimberly 3. And this one, you were charged with second-degree felony, assault. Looks like on a peace officer. Now, this carries with it up to 20 years in prison. Of course, it's a serious thing. And this is an announcement. What are we doing today?
Judge, I'm working through the discovery on this is Free's case, so if we can get one more resetting so I can work through that. I think there may be some legal issues with this one.
You got 3 weeks, okay. But you say there are some legal issues?
Yes, sir.
There's legal issues in every case.
I'm not trying to.
That's why we went to law school, because we don't do research. We don't do medicine here. It's all legal.
I don't know. Sometimes there are some strange things.
What would get my attention if you said, no, I'm doing an appendectomy today, and I don't have time to get to this trial. That would get my attention.
I'll toss a tonsillectomy later. But
yeah, I had one of those.
I stayed as a holiday in select last night, so.
Well, you know how to do it.
I know.
You're ready.
You're welcome.
George Moten.
You're interested, or you're steward. I'll be here all day.
Well, you heard the crowd response.
I know. I'm a lawyer, George, not a comedian.
You telling us? All right. Back to what's it?
Mr. Moten.
Yeah.
Well, there's some medical records that I think the defense has that wants to talk to Kenesha about that they haven't been able to. And she's at that seminar this week. So
This was an announcement.
yes, sir.
Again, that it's like one indictment was handed up in February and the other was in March. Injury to a child, which is a state jail felony, and then the continuous violence against the minor. That one's a new one. I don't think I've seen this one
It's pretty new
lately.
capital offense too.
And this is a third-degree felony. So between a state jail felony and third-degree felony, you're looking up to 12 years in confinement. Serious. And they're both felony offenses. You need how much time?
Just a normal reset, Judge. 4 weeks.
No, there isn't anything. I'm going to give you 4.
That's fine.
Okay. Justin Patterson.
Hey, sound like a broken record, Judge, when I'm working through the videos on this one. This is where he's indicted for threatening to assault and murder a peace officer. I've yet to find the part of the video where it says murder. I'm trying to work through the videos. There's quite a few on his case, so I can get another reset so I can continue to work with the videos on his case.
Okay, you or Justin Patterson?
Yes, sir.
Okay, you're charged with this third-degree felony of obstruction or retaliation, but that's not the end of it. You got 2 prior felony convictions, assault on a peace officer, which I can't imagine that that's going to play out well in a trial. With that, if that comes out during a trial, and then evading detention, all in 21. So if you're convicted of this third-degree felony, and if these prior convictions were proven true, you're dealing with a second-degree felony, up to 20 years in prison, and you're not eligible for probation in front of that. So there's a lot of things to think about. How much time for a decision? 4 weeks?
Yes, sir.
Okay. Well, should be set. Okay. And Jean-Claude Butler.
Okay. I think it's. Take it away from pain.
We'll leave that.
Good.
Got it? You can tell.
Thank you.
You know, what these, look, on these things that are motions for examination on insanity, yeah, I'd like those. Yeah.
Judge, this is, we're trying to renew the plea. This is one that, from Monday that the family's wanting to go through with this plea agreement on both sides.
If the court recalls, you indicated Monday we set a hearing for today. I presume with regard to the introduction of evidence to support an insanity defense.
I don't, like I can't remember since we disposed of 3,000 cases last year. This is a typical day. We're set for trial. So
No, sir,
there's a motion for examination regarding insanity. What do we do about that motion?
They were willing to waive that and plead
Is that what they're
deferred
doing?
probation on Monday. I don't know if they're still willing to do that or not. I thought that's what the plan was today.
I mean, it
To do
really
deferred.
depends on the court. And
What does it depend on the court on?
well, Judge, we were in the process of entering the plea on Monday when the court shut it down and said the court was going to put it back on the trial bucket. So if we're going to do that, then we're going to pursue that motion rather than waiving.
Well, obviously, what had been presented before me, what information I had, obviously caused me some concern to stop and back up and be deliberate on
Yes,
this.
sir. But speaking, this is something that the family was wanting you to follow, both sides, to make sure he gets some help. And I think this is the best plan to do that in the interest of justice for all
So
involved.
what would the plan be?
Be deferred and place him on the mental health caseload to make sure that he's taking his medications and doing what he's supposed to do for a couple of
Are
years.
the families here?
They're not here, Judge. They're watching on YouTube, but they've been calling. I mean, they've been calling your clerk also. So
How are they, are the families related?
yes,
Okay, this is an intra-family
Yes.
situation between complainant and victims.
yes, they're all part of one big family.
All right.
So the
All right.
paperwork, we still got the paperwork from Monday. I think we can still use.
That's what y'all want to do. Let's
Yes, sir.
follow.
Okay.
Is it on the, still on the pad?
Yes, sir. It should be from Monday.
Who it is? I think I logged into the wrong one. You want me to switch them?
They,
I logged in the wrong way. That and attached, that's hard.
this is working.
Okay, but I don't have a name to use. So that's okay. I don't need one. It's fine.
Well, hey, this thing is really hot.
Yeah, they're warm.
Do they,
It's fine.
sell them this one? Okay, we call then 25 CR 34, the state of Texas versus Jean-Claude Butler. That's you? You have to speak out, so this lady, thank you. And you hear Mr. Wilkerson is your attorney and the state's prosecutors here. You understand you're charged with a third-degree felony of injury to elderly persons, right?
Correct, Judge.
Okay. Does the defendant waive a formal reading of this indictment and arraignment? Can we proceed in summary?
Yes, Your Honor.
In summary, this indictment in late states that on or about November 2nd of 2024 in Jefferson County, Texas, you committed the third-degree felony intentionally and knowingly causing bodily injury to Solelo Richard Petrie, an individual 65 years of age or older, by striking that victim in the face with your hand. Do you understand what you were charged with, sir?
Yes, sir.
This is a third-degree felony, which means if convicted, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000.
Yes, sir.
An agreement has been reached where you would be pleading guilty and placed on deferred or unadjudicated probation, which can be up to 10 years in length. If you do well, I can shorten it to 1/3, which is 3 1/3 years. Yeah, I see there's a non-binding recommendation, but the court's inclination is to place you on 10 years deferred or unadjudicated probation, shorten it to 3 1/3 if you do well, which would be sooner than 5 years.
Yes.
Is this your understanding of the plan?
Yes.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
Let me ask you one. There was one other thing y'all had mentioned. Y'all had, I thought the parties had some agreed terms of medical or mental or.
We wanted to place him on the mental health caseload.
Right, everybody?
Yeah, sure.
The defendant would be placed on the mental health caseload, which means that the probation office would help you on issues that you need to address, maybe for anger management or something like that, that will help your decision making so that you don't violate your probation.
Yes, sir.
That's what we want. This court has 93% success on probation, which is 75% is the national average. We're real proud of our probationers. They do well. 13 out of 14 are successful. Is that going to be you?
Be successful, Judge.
Good. And if I follow this agreement, you have no right of appeal. Do you understand, sir?
Yes.
How do you plead to this third-degree felony? Guilty or not guilty?
Guilt.
Are you pleading guilty voluntarily and because you are guilty?
Yes.
Show you what's marked as State's Exhibit 1. Would you sign that voluntarily, understand it, discuss it with your attorney? Are the contents all true, correct? State's Exhibit 1 is tendered into evidence.
Without objection.
Without objection, it's admitted. This states that you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, and you were totally satisfied with the representation provided by your lawyer. All of this, it states, is true, so help you God.
Yes,
Correct? States Exhibit 1, part of the record for all purposes. Pre-sentence reports waived here.
Yes, sure.
I'm going to follow this agreement and find you are pleading guilty voluntarily, knowingly, intelligently, and based upon discussions with your attorney. There's sufficient evidence supporting your guilty plea here from State's Exhibit 1 admitted to find you guilty beyond a reasonable doubt. The court, though, is going to defer any finding of guilt so long as you follow the terms and conditions of probation that the probation officer will go over with you. And I am signing now. Now, there are 30 some odd terms and conditions of probation, but the overwhelming majority of these are the terms and requirements all of us have to follow. Commit no offense. Okay. Avoid bad habits. Don't associate with disreputable people. I can go on and on. See, these are like the blueprints for a good life. All of us should follow. Don't possess any illegal drugs. Dress appropriately. Things like that. Most of these are just requirements for a proper, decent life. So this shouldn't be hard for you to follow. You will, included in this, you will complete anger management program, and you will be placed on a mental health caseload, which the probation office has great success with in handling the folks. Very, very seldom do we have any problems. And the folks on the mental health caseload, many of them clear themselves of mental health problems. So it's a great program. But it's like everything else. We can put this all together, but it's what you make of it, what you do. You got to put in the heavy lifting. Are you able to do it? It's good for you. We're talking about family here, right?
Yeah, sure.
This is a family. Who chose your family? Our Creator did.
Yes.
Don't foul it up. You don't want to go get crosswise with the Creator. He's got a master plan. I believe it, and I know most people believe that. But family, you didn't get to choose them. I mean, you got the same DNA as many of them. You know, it's similar DNA in your family. They're special. You got to treat them special as well. Don't treat them like an enemy. And there's nothing more wondrous than a family that stays together and is happy together. Be part of that. This you're an outsider now here. Fix this. They want you back. Get in there and do the heavy lifting and be a part of your family moving forward happily together as a family. See the probation office.
This case was about much more than a guilty plea. It was about accountability, second chances, mental health, and the choice to rebuild a family. The judge made it clear, probation is only an opportunity. What happens next depends on what the defendant does with it. What do you think about the judge's decision and his message about family? Share your thoughts in the comments. And if you enjoy real courtroom moments, powerful judge reactions, and stories where every decision matters, subscribe to the channel and turn on notifications so you don't miss the next case.